begin, my
Yes,
lord?
Mr.
I appear, as you know, on behalf of the appellant.
Yes.
And my learned friend, Mr. Vickers, appears
Vickers.
on behalf of the respondent. My lady, you're concerned today with a child, N, who that's what I shall refer to them as, and just at the first set, to say there is a transparency order in place.
Well, that no longer applies, of course, because that is family proceedings rules, and we're now governed by the CPR.
Yes.
So this is a court of record. This is an open hearing, public. So the parties may be named. Rather bizarrely, we got sent a redacted skeleton argument. I don't know why that was. But the parties will be named in the normal way because of this as the Court of Appeal. But of course, the child must not be identified.
Indeed. And therefore I shall, as I've said, refer
Your
to
juniors are looking mystified. Would you like us to look at the law on this?
No, I don't think so, my lady. Although, may I just turn my back to Mr.
Certainly.
Lamar? My lady, I think the concern is, and Mr. Duval's here, in terms of those issues, the reporting issues, is that the transparency order has other elements within it that could lead to the identity of the child, which were prevented under the umbrella of the transparency order. So in terms of that, if the transparency order isn't, as it were, complied with, certainly by the press, then it will lead to the identity of the child. I think that was the reason for the concern.
Well, the position is that we are in open court. We're dealing with the appeal, which relates to costs. The child will not be identified. I don't know whether the press have been given skeleton arguments or not, or whether they've asked for skeleton arguments.
Not to my knowledge.
There we are.
I think that's the basis upon which they were redacted, was because the identifying information and the transparency order, which was extended, of course,
I saw that,
until
yes.
the 18th birthday. If some of those elements were to be reported, there is a real risk of identifying the child and jigsaw identification.
Well, that I'm afraid, given the publicity this case has had and the amount there's been about this child on social media, is a challenge in any event, I would have thought, jigsaw identification. But obviously the press are always, in my too extensive experience, extremely cautious about protecting the identity of children. And I know that I can count on any press. I don't think we've got any press in, have we?
We may not have them in,
but online, I'm sure we may have people online. But that my experience is we can trust particularly the press that attend hearings in relation to children to respect the terms of that transparency order, although it has no direct impact on our hearing today, and that they won't do anything to jeopardise this child and to risk identification. And I'm sure any press online will be conscious of that.
Lady, I'm grateful for that. Some components of the transparency order, of course, relate to the parent's identity.
Well, I'm afraid I can't help with, but I'm very content if either of you wish us to just refresh everybody's memory about what the relevant law is on that topic, or if you want to look at the white book and see what it says about it. I'm very, very happy to take you to it, to remind you of it, or you perhaps ought to be reminding us, but I'm happy to remind you.
Lady, I think on the basis that what you've said in terms of any press online and the terms of the transparency order, I don't envisage that would be necessary. But may I just turn my back? No, thank you, my lady.
Not at all. Now, before you get into your stride, if I can just say to both of you that we've had the opportunity of reading extensively into this matter. So we've read all the relevant judgments. We've, I think, all read pretty extensively into both the core and the supplementary bundles. and of course the law is extremely well established. So I would hope from both sides that we will be able to deal with this matter reasonably briefly.
My lady, I think that's right, and thank you very much for that indication. I think if you've all had the opportunity to read in that way, then I certainly would hope to be succinct and to the point, and simply flesh out a little bit, because it's fairly fleshed out in the skeleton argument, what the points are in respect of the order which we are appealing, paragraph 8 in particular, which is at 56 of your bundle, which was the order of Mr. Nicholas Allen, KC, sitting as a Deputy High Court Judge. He heard the matter, as you know, on the 25th and 26th of February, and his judgments, because there were two of them, followed on the 8th of May. And is, in essence, paragraph 8, he made a costs order against the appellant to pay 75% of the respondent's costs. It is that paragraph, really, that we ask you to consider today. There was an application for a stay, but your ladyship, I think, dealt with that, and indeed gave permission to appeal the order on the 18th of July. That's the very last page of your bundle.
I can't find in the bundle the actual statement of cost that was before the judge.
It's not there in the bundle. The only N260s that certainly I've seen in the last 24 hours are those for the appeal. But you're absolutely right, the N260s for that hearing, and the ones that were before the judge are not in the bundle.
Well, I'd like those to be sent through, please.
Yes, of course. Of course, you have within the judgment, and I know you know this, you would have seen reference to the sorts of figures that were being claimed, and also that they covered pre-proceedings, particularly in the case of the respondent, as well as during the proceedings. And during the course of the hearing, it was requested that the appellant give an indication as to the costs he had spent, and that was done as well. Because there was a potential argument, or so it was said, about privilege, but those were offered up very easily and almost immediately, and certainly within the timescale that the judge had given. So when the judge came to the 25th of February, as you would have noted, there were really three issues before him. The first one was the application for costs, and that was due to be dealt with originally on the 16th of September. But in fact, the court ran out of time because there were the transparency issues, if I can call them that, and the judge made directions in respect of that. So by the 25th and 26th of February, it was the costs in the Children Act proceedings, the transparency order extension, and the duration of a Section 9114 order. Those really were the core issues before the court at that juncture.
Had the Section 914 been conceded? Was it just the length of it that was being determined on the 25th?
Yes.
I mean, I knew it was ultimately conceded. I don't know if it had been conceded before the morning of that hearing.
In my position statement, which I believe was dated the 22nd of February,
right.
Mr. Vickers says it was filed on the 24th, but it was certainly completed on the 22nd of February. It was said within that document that the father accepted there should be a Section 9114, but in fact it was the length of that order, and the judge heard submissions on that and pinpointed the duration. So that was the only issue on that aspect, and he gave an extempore judgment on the day.
We read.
Thank you. So in terms of the issue of costs, you would have seen from the grounds of appeal, and I know you've read in very well to the papers, and I'm grateful for that, but if I could just give you a whistle-stop tour of how the proceedings themselves evolved, because one of the things we say that the judge did not attach sufficient weight to was the fact that the appellant, at every stage of the proceedings, right up until the extension of the transparency order, which of course was granted, was successful in pursuing aspects of his case. So the first point, and there was a sea change.
Was what in pursuing? I missed one word.
Aspects of his case.
You said he was something.
Successful.
Successful.
Yes. So, my lady, when these proceedings first started, they didn't start in a vacuum. As you would have seen, there were 3 years of inter-solicitor correspondence, which covered a myriad of issues, including finances, some issues about privacy, and of course, most importantly, building up a relationship with N, which had not at that point been achieved. So when it came to the courtroom, it was really as a last option and a last resort from the appellant's perspective, because nothing had been achieved during that correspondence. And I'll return to that in due course. But certainly in September 2022, when the application was issued, at that point, there had been every attempt. And as I said in the skeleton, had it been post the rule change in 2024, and had there been an FM5, which is the form, of course, that everybody now has to fill in to show that they've attempted non-court dispute resolution in family proceedings, the father would have been able to list there all of the things that had been attempted, including therapy, which in fact the father had funded. So,
well, just a moment. I think their lordships probably need a little more information about what an FM5 is and and identify the rule, please.
yes, so the rules changed in April 2024. Previously, mediation still is voluntary, but now before one issues an application in the family court, one has to show on a form, the FM5, that one has tried various methods, if any, of non-court dispute resolution, and if not, why not?
And the rule number?
I don't have that to hand.
Perhaps one of your juniors will dig that out
but
for
certainly
us.
that can be pulled up for you. But that form was born out of the change of rules in the hope that would cause a sea change in how the family court approach these, and to, of course, limit the applications in private law proceedings, which the statistics are, of course, troubling, because there are a number of private law cases within the court system and there is a significant backlog. So that was a...
Thank you very much. I'd worked out what NCDR meant, but some of the other acronyms are a bit more challenging.
Yes, I apologise.
Not in the know.
But the FM5 is the form which sets out, and the point I make is simply this, that had the rules been in place, the father would have been able to evidence back in 2022 that essentially he tried everything in terms of non-court dispute resolution. And so it came that the case proceeded in a conventional way, and by that I mean this, that the parties in fact had agreed how that case was to proceed, in the sense that the mother had chosen an independent social worker. In the usual way, 3 names were provided, the mother chose one, and she was instructed to essentially set up and introduce N to the father, and to facilitate and support that. So that was agreed, and in fact, as a result of that agreement, the first hearing, which is called the First Hearing Dispute Resolution Appointment, the acronym of which is a FHDRA, or some people call it a FHDRA, I tend to call it FHDRAs. But
so first hearing
dispute resolution appointment, which was listed initially on the 18th of January 2023, was vacated.
Sorry, take me that date again.
18th of January 2023, consent order made, but no attendance required because the parties had agreed a way forward. It's worth noting as well that the judge in that case made no order as to costs because there had been consensus about the way forward. And I should say...
So just tell me, sorry, but the judge made no order for costs.
Yes.
So the 500,000 plus, which was, did that include costs relating to that? I mean, did that seek to go behind that no order for costs?
When we first...
If so, had an application been made, set it aside? Or was it just rolled up into the...
It was all rolled up. I think the N260s set out pre-proceedings and all of the proceedings. But of course, it was acknowledged that the no order as to cost. And I'll come to the next hearing because that was the same as well. Those two, in any costs order and detailed assessment, we say would be excluded in any event because no order as to cost was made.
Right, okay.
So so that was vacated. But one thing I need to point out in terms of the case itself is that in the usual way, and here comes another form name, the C1A was lodged, which is a form which sets out allegations of harm and domestic abuse, and the father responded to that swiftly, and within that accepted, as he had in correspondence, that the behaviour had caused harm and had apologised for that. So those allegations were before the court at the very early stages, as they would be, because it's practice to lodge that form at the commencement of the proceedings.
And we don't have that form, do we?
No, now that isn't in the bundle. I certainly asked for that to be sent in another bundle to me, but we didn't obviously want to overload the court, and we haven't.
I'd like that
agreed
also,
it.
because it wasn't until some time later that the schedule, what became the schedule of admissions on behalf of the father, was filed in the February.
Yes,
But I just wanted to see what the allegations were compared to the concessions that were made.
well, they morphed the allegations, and I'll come back to that at the moment. But the C1A, what you will have with that form are the father's responses to the allegations in the C1A, and you will see what the father was accepting there.
Yeah.
Which is at the very commencement of the beginning of the proceeding.
I think we need a copy of that, please.
Yes.
Sorry, add that to the Union's list, please.
So the case marched on, and it was listed for on the 18th of April 2023, a dispute resolution appointment, or what is now called a DRA. And on that occasion, in fact, there was a plan put forward by the independent social worker, which I shall call phase 1, which was a plan for N to meet with the father and have several contact sessions. And both parties signed up to that phase 1. And I should say, at that hearing, the mother was represented by leading counsel, whose position statement acknowledged that the father had accepted the harm caused, and everything was agreed. So again, the judge was faced with a situation in which the parties were agreed on a way forward, and what is important is at that juncture, which would have ordinarily been the point at which this would have been raised, there was no mention of any separate fact-finding hearing about the allegations of domestic abuse. That simply wasn't raised. Everybody was travelling in the same direction towards a point where N would meet the father and the contact would happen in phase 1 as directed by, or recommended, forgive me, by the independent social worker.
This is why I wanted to see the C1A, but I'm right in thinking, aren't I, that the allegations of domestic abuse, which the father accepted, related entirely to his deception.
Yes.
In relation to the mother.
Yes. And the responses, and there in his first statement dated the 31st of January 24, which you do have in the bundle, paragraphs from paragraphs 14 through to 19, you will see that there is a wholesale acceptance as early as January 2024. I say as early, that was only because the judge in November had to direct statements because the allegations became were put on a slightly different footing, which I'll come back to. Okay. But certainly within that statement you will also find wholesale apology and acceptance. So that is where you will find that, and in my submission that is quite important because there has been admissions and acceptance. I appreciate there wasn't a schedule, but the judge early on in January 23 and April 23 didn't have to grapple with that because it wasn't raised in terms of having a separate fact finding. And so on the 18th of April 2023 everything was agreed and the parties went away, and within days of that hearing N met the father. That went very well, and if you've had an opportunity to read the independent social worker reports, they speak positively about that and how the relation evolved and developed, certainly from the beginning right through to...
What's the tragedy of this case?
April 2024.
I reread the independent social workers report of the visit that took place in August 2023. It went really well, parents working well together. Mum had felt able to put the past behind her in as much as she ever was going to realistically be able to, but in the interest of her child, and it all fell apart the following month.
And in the father's statement that was filed for his withdrawal in September, he says that the April 2024, which we know is the last one to date, was one of the most successful in London over 3 days. and that went very well. So those reports, I know you've had a chance to read them, they speak very positively about that and the father's commitment to that. In fact, at one point, the independent social worker says she doesn't know, he'd done everything he could at that point, travelling the geography, as you know, which is lengthy, and from country A to country B. So from that perspective, April 2023, no order as to costs, because there was full agreement. And I know one of the points that is alluded to, but the judge didn't take up, to be fair to him, in his judgment, is that the father had issued an application just before the 18th of April 2023 for a specific issue order about reporting. There were articles, things happening, documentaries, but in fact that was withdrawn and permission was given on the day. Mr. Hale KC was able to deal with that in his position statement, and it was agreed that that was not the appropriate application. So this wasn't a case, this isn't a case where there is a pattern of withdrawals or last minute withdrawals. There's no such pattern. It was one and it was withdrawn on the day, and the judge made no orders to costs and knew the logic behind that, because I represented the appellant and Mr. Hale, King's Counsel, represented the mother. So at that point, the case was headed on a fairly, I'm going to call it, conventional trajectory, whereby things were going very well. The report, there was another report from the ISW, but then in September 2023, there was a significant, we say, as you know, sea change. There was different representation, the mother's full set of solicitors, and very quickly it became apparent, by virtue of their letter of the 25th of September 2023, that the case now was taking a different path.
Is that letter in the bundle?
It is.
Page.
Let me just, I've got four bundles.
In the supplementary bundle, I presume.
Something like that. I believe it's in the supplementary bundle.
Can't see it in the index.
No.
It's one of the exhibits to the statement that my client filed.
Perhaps someone could just find us the reference for that, please.
Yeah, it's in the. It's this.
Oh, I'm sending you the C1A.
No, this is the 25th of September, and it's not where I thought it was, lady.
Well, don't worry, we can.
Lady, I can get my junior reference. It's at 2 points, but it's in the exhibits to the statements. But we will get you that reference. But yes, it's in the bundle.
Thank you.
But that letter, it has a very different complexion. And there's another document that will expand on how that changed. That document you will find in the supplementary bundle, which was the position statement filed on behalf of the respondent.
Is that Dr. Proudman's?
It is, at page 52. So you will see from the letter,
Can you give me that reference again?
that was the supplementary bundle, page 52.
Thank you.
Thank you.
And the combination of that letter and the position statement filed really, as I say, was a sea change in the way that the case was now being pursued.
It's perhaps paragraph 26 in particular that sent the temperature soaring.
Yep.
And also, one of the things you would have probably seen from Her Honour Judge Roberts' judgment in February is that now there was an emphasis on labelling the domestic abuse, and that became, and characterising it rather than accepting the umbrella term, which of course we all know is defined in any event, this was about specific labels, which was something that Her Honour Judge Roberts did not think. She said she was far from convinced that the father needed to concede in those terms, and indeed the Deputy High Court Judge agreed with her when he came to consider that again on the 16th of September 2024.
So in that position statement, there's no need for me to read out the inflammatory parts of it. But on the one hand, a finding of fact hearing was being sought, but on the other hand, the mother was asking for the child to be introduced to the paternal family, and there to be a family group conference.
Yes.
To that end.
Lady, that's been a theme.
I understand, but I'm just clarifying that that's what the position was.
Yes. And also, I know we haven't referred to it, and I'm sorry, my lords, I didn't, but the safeguarding letter, which is a document from CAFCAS, who are the independent eyes and ears of the court in children cases, as you know, possibly. They had filed a safeguarding letter at the beginning of the proceedings, so before the January hearing, and within that they had, of course, as they must, referenced that there were allegations of domestic abuse, but they said in terms that this wasn't a barrier to contact. And of course, the court would have had that letter at the very beginning of the process.
But clearly, to her great credit, given what happened, the mother didn't think it was a barrier to contact, and indeed still doesn't.
No. And that's why when September 23 letter came and the position statement, I think certainly from our client's perspective, that was a watershed in the proceedings, to the extent that now things were being put on a very different basis, and also the case, I think Mr. Vickers was attributed with the word mushrooming, but in fact it was my phrase that I used when I made submissions. And I don't suggest for 1 minute that Mr. Vickers was trying to take credit for that, but in the judgment...
So it was worth a go, Mr. Vickers.
The Deputy High Court Judge says using his term, but the phrase I used in submissions to the judge was, this case really did mushroom at that point, because it turned into something...
Another way of putting it, it went nuclear.
It went nuclear.
Again, the mushroom image.
Yes, that's exactly what happened, and changed, I would suggest, the course of these proceedings very much.
So very unfortunate.
And I add in here, because I know this is an issue, that as said in our client's statement in the January, it had a significant effect on his mental health. Now things where he thought things were ticking along rather nicely. Everybody was agreeing on the phase 1. The ISW was facilitating the contact. Of course, the father funded all of that. He was happy to do that. But here we were now with a very, very different path of litigation. And what happened in the November, so it came back before the judge. The same judge has presided over it on the April hearing. And that judge now was faced with a situation where, in the usual way, case management, statements about allegations, setting it down for a hearing at which a judge would have to decide whether a separate fact-finding hearing was necessary on the allegations. So
the November hearing was a directions hearing, but it wasn't making an order for a finding of fact hearing. What it was doing was saying, right, so because at that stage Dr. Proudman was saying that there should be a finding of fact hearing, and so directions were made to provide evidence in witness statement form so that the judge at a next hearing could make a decision about whether or not there should make a finding, whether it was necessary in the welfare interests of the child for there to be a finding.
Exactly, and that tends now to be the case management path.
Yeah.
Because a judge will need to see what those allegations are, and then determine. It's a big judicial decision. Practice Direction 12J, again, forgive me, but that is a document that deals with allegations of domestic abuse or findings and how we are to deal with them in the family court. And so it was. One thing I will say, and I know this is in our skeleton, and so I may not expand on it later, but I mention here that on that occasion it was asked that the statements be 25 pages. Dr. Proudman asked that the statements be 25 pages, and the judge made a decision that they should be no longer than 14 pages, and there should be a statement from each of the parties. Again, not an unusual case management decision.
Well, I think if my recollection's right, it had the normal, as you read me, in 12 font, 1.5 hour spacing.
It's a standard order within the family court. What happened, as we now know, is that there was a breach of those rules, and that the font was all squashed in. And in fact, what we got, or what the father got, was 52 pages of narrative, a statement from the mother, a statement from the sister. And Dr. Proudman, even though the judge in April and the judge in November said that our position statement should be no longer than 6 pages, Dr. Proudman, I'm afraid, filed position statements of 9 and 10 pages. So there was a breach of those directions, and it has never really been answered. And Her Honour Judge Roberts, in her judgment on the 8th of February, raised this. Yeah. Well, I have no clue really why this happened when court directions are there to be followed, but that's how the pursuit of the litigation, if I can call it that, or the way that the case was proceeded with, developed. So after that, statements were filed, and Her Honour Judge Roberts, who of course was the designated family judge at the Central Family Court before she retired later that year, came to deal with the matter on the 8th of February. And you've seen her judgment, I'm sure, in the bundle. Supplementary bundle, 224, I believe. That is
8th of February.
Yes.
Now, just give me a moment.
$223, technically it starts, but the transcript itself on 224. The supplementary bundle. My lady.
So I'm sorry, I'm just wanting to put this into the context of Dr. Proudman's position statement.
Yes,
and also just a moment, and the position that was ultimately taken at the child arrangements order hearing, because Judge Roberts, paragraph 9, specifically says that she did not find it necessary for the father to concede.
Yes.
In the very inflammatory terms that Dr. Proudman was suggesting to describe the same behaviour.
Exactly so.
All right. And was there any appeal? Was there any application for permission to appeal against that refusal? Okay, thank you.
And just on just so you have it, 224, just above paragraph 5, you will see that Her Honour Judge Roberts herself says, for reasons which I'm unclear about, this approach of not needing to go further into the past and its impact on the present, and that contact should just progress, changed in November 2023, well over a year after the court proceedings. And then she goes on to be critical of the fact that statements were filed and longer position statements. So that was the 8th of February, no appeal, as you say, and the case marched on. I say the case marched on. Of course, the ISW, the Independent Social Worker, forgive me, was tasked with doing a Section 7 report. And that was to be filed by the May 2024, dealing with the relevant paragraphs of Practice Direction 12J, which specifically focus on the risk in the future and all of those things that are set out. So that's what...
Sorry, just give us the paragraph of
I'm so sorry.
Just give us the paragraph again.
Of Practice Direction 12J, paragraphs 35 to 37, specifically 36 and 37, set out a roadmap of the points that a judge would need to consider when contemplating what risk, if any,
So the independent social worker was ordered on the 8th of February to prepare a report addressing those issues. Thank you.
And then the matter came back, I'm almost there, my lady, forgive me, the 3rd of June, a dispute resolution appointment to see where we were. And of course, when the matter came back then, and I should say, so forgive me, in terms of Her Honour Judge Roberts, what wasn't agreed is the number of hours that N should spend with the father. And at the earlier hearing, Her Honour Judge Roberts took the view that there should be an extension of the time that N spent with the father. The mother didn't agree with that, but Her Honour Judge Roberts took the view that, in line with the ISW recommendations, that should move on. So that was another thing along the way that the father persuaded the court was appropriate for N. At the dispute resolution or appointment, or forgive me, the DRA, the matter was then listed for a welfare hearing in September of 2024. And at that point, it was going to be a welfare hearing, potentially with the mother no doubt seeking to pursue allegations. Sometimes we call that a rolled up hearing or a composite hearing.
Sorry, just a moment, Tom. Can we just turn to that? I'm just looking at that order.
The 3rd of June.
So, sorry, it was just that you said
Yeah.
that no doubt finds of fact and so on will be sought, but there'd been the application for finding of fact hearing had been dismissed,
Yeah.
and this was welfare only. And I'm looking at the case management, and the case management orders, paragraph 10, where the father's application for PR, pet parental responsibility, and the future child arrangements, including long-term arrangements.
Yes.
So there wasn't scope there for findings of fact.
No,
I think the judge had said in the previous judgment
You're right.
that the welfare hearing could also make some findings.
you're exactly right, my lord.
Right.
So in the judgment of the
thank you.
8th of February, what the judge said is that she was far from convinced that that might be the exercise the court would go through, but the door was left
thank you.
open
Thank
for
you.
an element, as I call it, of fact finding. So you're absolutely right.
Let me just find-
That's exactly why
Let me
I
just
said what
find
I
that
said.
passage up.
So whilst Her Honour Judge Roberts was far from convinced, what she didn't do is tie the hands of the judge who would be dealing with the welfare hearing. So that door was left open, if I can put it like that, my lady.
So are we just thank you.
And of course, as we now know, the Deputy High Court Judge on the 16th of September also said that he aligned himself at the very end of his judgment. He says he aligns himself with Her Honour Judge Roberts and did not see the need to characterise or label the domestic abuse. So he shared, in fact, the same opinion, but Her Honour Judge Roberts was leaving that door open just in case another judge took a different view. But certainly, just so you know as well, on the schedule of recitals, which is at 44, the order you've just been looking at, my lady, just towards the end, the schedule of recitals, where at paragraph 26, the father again accepted that the behaviour constituted domestic abuse of an emotional nature. So that again shows that the father's position throughout has been consistent. And almost at the end, my lady, now, because one of the things that the father says is that he, between July and August, he says this in his statement, between July and August, he was struggling, he was trying to contemplate what was best. By July, August, 2024, he had taken, to use his phrase, a step back to think about the proceedings. And on the 14th of August of 2024, a letter was sent to the mother's solicitors to say that he had reached the difficult decision that he would be seeking permission to withdraw the application at the next hearing. Now, what that triggered within the court system, because the Central Family Court have a very good system where it will find its way back to the judge, and of course Her Honour Judge Roberts was the designated family judge, is when she received that application, and obviously not in the presence of any of us, on an administrative basis, she reduced the 4-day time estimate to a 1-day time estimate, having received that application. Bearing in mind she'd had carriage of the case for some months, and so she did that. And so there was a 1-day hearing listed now on the 16th of September for the purposes of the father's withdrawal application. Can I say this, that in the second statement filed by the mother, which, as I have said, what happened in that statement is that there were exhibits which are long narratives about how the mother is thinking and feeling about things. And one of the things in that statement, in an exhibit, and it is referred to in the statement, is that she said that she wouldn't be surprised if the father orchestrated a fatal accident for the child. And I can tell you, my lady, because we had instructions on that, that really, from the father's perspective, was extremely troubling, deeply concerning and worrying, because that was now, we'd gone through the process, the statements had been filed, and here was the mother now saying, well, I wouldn't be surprised if he orchestrated a fatal accident for N, which of course had a significant ripple effect on the father's mental health.
Sorry, where do we find that?
That is, again, it's in the supplemental bundle. I want to, it may be at 154, isn't it? 153. 153, yes.
The supplementary bundle.
Or is it the main bundle? Supplementary. 153, my lord.
Thank you.
So I'm just finding the paragraph.
Do you have that?
13, my lady.
It's supervised contact underlined, so it's the last, penultimate paragraph, forgive me. Well, this is the point I made, forgive me, we made in the skeleton. This document, this is an exhibit to the statement. So if you look at the 147, Exhibit 5, grounds for opposing parental responsibility application. That's what the document was. So the second time around, rather than go past the page limit, what happened in the format of the statement is there were lots of these things exhibited to the mother's statement, which, as you know, we say that's unreasonable litigation conduct, actually. But that's what kept happening. There was no change, despite Her Honour Judge Roberts raising this, and of course myself. But that is what we got. So this is an exhibit to a statement.
This is in the context of the mother agreeing that contact should continue and that she wanted to have a relationship with the father's family.
Yes, all of the above.
Right, thank you.
Travelling, if you will, then to the 16th of September 2024, this was in front of the Deputy High Court Judge, and the application was for permission to withdraw the application for a child arrangements order. That was opposed, and a parental responsibility order, which was agreed. So the mother was content for that to be withdrawn, but not the application for a child arrangements order. And I know you would have read the judge's judgment in that. He took a very similar view to Her Honour Judge Roberts. He agreed with our submission, which was that the proceedings really had run their course. Contact was agreed. The only thing that the issue was frequency. There was also an allegation now by this time that the independent social worker was biased, although that allegation had been in play for a significant period. Of course, the independent social worker was the mother's choice when she was represented by leading counsel. So from that perspective, the situation really, that's why I say that the case really went off the rails.
Can I check on one other procedural matter?
Yes, of course.
So we'd had the February refusal of a fact-finding hearing. We'd had no appeal. Was there a fresh application, formal application for a reconsideration of there being a fact-finding?
No.
So it was just simply rolled up in the opposition to the child arrangements order.
Yes, and I think what the same submission was effectively run about the need for the court to have a full judgment, to have it there on record about what the father had done, and also that there were specific labels or characterisation of the domestic abuse, and you know the terms I'm referring to. There was certainly a push to do that, but the judge, the Deputy High Court judge, did not agree and said, no, I agree with father. I think the time has come and I'm going to give him permission to withdraw. The test, of course, was there a solid advantage to the child with the proceedings continuing? He fell on the line of there was actually a solid disadvantage to those proceedings continuing. And so it was that on the 16th of September, the court gave permission to the father to withdraw his application. What was left over, of course, because we ran out of time, is the costs and, of course, the Section 9114. And can I just say something, because there's an element of criticism of the father. At the hearing in September, the father wasn't conceding the Section 9114 at that point, because his case was, well, I'm withdrawing the case, I'm not going to be coming back, I don't see the need to have that filter, protective filter, in order for future applications. And you will know that by the time we got to court in February, the father had conceded that. There's criticism of it being late, but I'll come back to that because I say that is not unreasonable conduct, litigation conduct, despite the fact that it appears to be one of the grounds upon which the judge made his decision. And so we came then to the 25th and 26th of February. Forgive me for, I said a whistle-stop tour, it's rather longer than a whistle-stop tour, for which I apologise, but hopefully that will set out the case management and how we came to be where we were. Then, of course, the judge, over 2 days, gave an extemporary judgment on the duration of the Section 9114, but he also dealt with the issue of costs on submissions. It was never anticipated there would be oral evidence, and I think that's agreed. And I think you, just so while we're on this topic, there was obviously not going to be any oral evidence on the 16th of September, unless it was the independent social worker, who I should tell you was at court, just in case the court called upon her. But in fact, with the transparency order directions and the issues that we were dealing with, the withdrawal of permission, and in any event, the way that the judge, Her Honour Judge Roberts, had reduced the time estimate, Mr Vickers and I agreed that if the judge was with the mother and there was to be a welfare hearing, that would have to go off for 3 days with oral evidence. So there was no chance with respect of there being oral evidence from the parties on that occasion, nor I would say on the 25th of February. The reason I say that is one of the criticisms of the father is that, well, he didn't turn up on those days. Maybe he was trying to avoid cross-examination. I mean, that was shot down in flames, I think, by the judge. I don't think the judge aligned himself with that submission, but that was the criticism being made, when there was clearly, that was not what was envisaged. And so the judge listened to submissions and he determined, as you know, that the father had been unreasonable within his litigation conduct. I don't think he calls it reprehensible anywhere in the judgment, but I'm sure I'll be corrected if I have that wrong. But it was unreasonable litigation conduct, and I'll come to the reasons why he says that. And as a result, he should be paying 75% of the costs. Now, these were not, as you know, small costs. You know the sort of...
Well, I mean, let's be having the figures. You're not going to identify the child by telling us the figure about
£514,111.97 from memory for the mother. 404,444 for the father, save that excluded the costs of the independent social worker, which were about £46,000. Because, of course, the costs required flights. It didn't all take place in London. The contact took place, as you know, globally. And so those are the costs on both sides. And there was no problem. The father was very happy to provide those costs, as you saw, through me. And so those are the costs we were talking about. So the judge made his decision, and the father took the view that we should seek permission to appeal. We did. The Deputy High Court judge refused, and of course your ladyship said what we said, real prospect of success, that this was not unreasonable conduct and not in the category of exceptional cases, exceptional circumstances. So here we are. And just on the law, I don't think we need to spend much time. It's very settled. To be fair to the judge, he accepted a document that I drafted. Mr. Vickers looked over, it was agreed.
Have we got it?
Not in the bundle. I've got it because it's my document, but certainly if you wish to see that document.
Well, but I think it'd be useful just to see the basis that the judge was,
yes,
the agreed basis that the judge was approaching.
Yes, and I think to be fair to the judge, within his judgment, he essentially adopted that template, if I can call it that.
I don't know if this has helped. I've just done a quick search. In the judgment, the judge uses the word reprehensible.
That he does, but is it in respect of litigation conduct or behaviour?
No, exactly, that's the point. It goes without saying that F's conduct towards M was dishonest and reprehensible. She was grossly deceived.
Yes.
Paragraph 57.
That is, of course, with costs orders, as we know in family, it doesn't relate to the behaviour, but to the conduct of the litigation. But I appreciate he said it about the behaviour, but not about the conduct. The phraseology that he
your point is he did not say it about litigation conduct.
No. He said unreasonable, of course, several times, but not reprehensible. But I absolutely accept that the behaviour was defined as such. Just so you know, lady, that where the judge deals with law within his judgment is from paragraphs 26 onwards at page 63 of the core bundle. And that, and Mr. Vickers, I hope will agree, reflects in large part, if not totally, the document that we produced, except for the RE, which came in, Lord Justice Peter Jackson's decision, between the hearing and the judgment. And I think, sent it to
I was going to ask, yes.
So he had that, because if you look at his judgment, he definitely had the benefit at paragraph 36, most recently in RE, children costs, Peter Jackson said.
Yep.
And can I just take you to that, because it'll save me taking you to the bundle of authorities. It is, of course, paragraph 23 of another of Lord Justice Peter Jackson's well-crafted judgments, where he says, and he condenses there, if I may say so, all of the authorities, including those from the Supreme Court. General practice of not awarding costs against a party in family proceedings, but the court retains a discretion to do so in exceptional circumstances. And of course, you will know that part of our submission is that these were not exceptional circumstances. This case does not fit into that bracket at all. He says it includes both reprehensible or unreasonable behaviour in relation to the proceedings. That again is drawn from the case law. It applies to public and private, we know that, and whether or not a party is legally aided. No difference in principle between fact-finding hearings and other hearings. The court can make a cost order at any time. These are principles, I would suggest, and that's why he said later on in his judgment they're simple, they're flexible, and they're well established. I say that's really the full compass of all of the authorities there in a simple format for the court. So I'm not going to deal with the law unless there's anything specific that you wish me to do so. Thank you. can I then just turn to our grounds, and before I go to put the flesh on the bones of those grounds, can I just give you the references for where the judge's rationale or reasoning was within his judgment for the various points. So the first one is between paragraph 61 to 86 of his judgment, which appear at page 70 of your bundle. This is where the judge landed on
Sorry, say that page reference again.
page 70 of your core bundle, paragraph 61 to 86 of his judgment.
Thank you.
That is where we say his reasoning starts. He calls it determination, to be fair, so it's fairly obvious. And he goes through what he suggests are examples of unreasonable conduct. Now, the first one, paragraph 61, really deals with the idea that he was able, from 4 letters, to make a substantive finding that protecting privacy and reputation in pre-proceedings letters amounted to unreasonable conduct. He said it was a motivator, or in part a motivator for the application. Now, our submission to you, of course, is that he wasn't able to do that. These in the pre-proceedings period lasted up to 3 years. Now, within our bundle, and it's all very well for Mr. Vickers to say in his submissions that, well, the father could have produced this correspondence. There was no proportionate reason to include 3 years of and most of it was without prejudice, I should add. But those 3 years covered everything, most importantly from the father's perspective, his relationship and introducing N to him. It covered finances, which the mother seemed to be very keen to do, and I'll come back to that. And it also covered elements of privacy, because as you said earlier, milady, and I'm not going to take you to various references, but there's an element of publicity in any event. There was social media activity and the like, there were articles, all of those things that were carrying on as well. So this correspondence was, it really was a Pandora's box of everything that the parents were trying to sort out. And so what the judge decided to do, and Mr. Vickers took him to a couple of those letters and used them to justify unreasonable conduct, the judge used those letters to arrive at a conclusion that this was a motivator, and that the only reason, or part of the reason, forgive me, that the father issued his application in September 2022 was to gain the protection of the Administration of Justice Act, Section 12 and Section 97. So all of the 3 years, and there are letters on the father's exhibits which show that he was asking about his child's habits. He was asking about what she liked, what she disliked. This wasn't just somebody who was motivated by privacy, and nor was there any indication that the Children Act proceedings were taken to preserve privacy and reputation. In fact, he could have, forgive me, my lord.
No, I was interrupting you. Finish.
He could have, as I said in our skeleton, he could have in fact sought injunctions. In fact, that was a theme that was certainly raised along the way, my lord.
Have I understood the position correctly? With the passage that you're talking about, or the passage of conduct before issuing a proceedings, his conclusion is at 65.
Yes.
Where, have I understood this correctly? He says expressly, I do not find that F has been primarily concerned not with C, their welfare, and to have a relationship with them, but to protect his privacy and safeguard reputation. So, am I right in, and this may be something for Mr. Vickers, am I right in understanding that to be a finding that desire to protect his privacy and safeguard his reputation is not a primary motivator? What is the primary motivator is he's primarily concerned with C, their welfare, and to have a relationship with them. Or am I reading too much into it?
I think that's how I read it.
I'm sorry, my
That's
lady.
how I read it also.
I, as far as I'm concerned, yes, he wasn't saying it was the primary motivation. He acknowledged, he didn't go as far as the mother had asked, which was to say that it was all motivated by privacy and reputation elements.
There's no suggestion that this secondary motivation has made any difference to the conduct.
No, but he classifies it in the same paragraph as unreasonable litigation conduct.
Well, I know he does. But what I'm troubled by is what the logical basis for that is. If he finds that the primary motivation or primary concern is with C, their welfare and having a relationship with them, and he doesn't demonstrate or even assert that the conduct is different or materially different in so as to justify a finding of costs. If it doesn't make any difference, what does it matter?
I agree.
And I'm not, sorry, just one more thing. I'm not a specialist in this area, as you will know, but it seems to me intuitively likely that you often have, in this sort of litigation, people's primary concern being the child or contact with the child and so on. But a secondary concern may be to protect. And my instinctive reaction, but I would welcome your response if you think it's appropriate, is that that's not unusual at all.
No, we agree. We agree. It's not.
The judge had previously made quite a big point of the order in which things were put in one of the letters,
Yes.
which well, that was feeding into a finding of the father's order of priority, although it seems quite a stretch.
It is a stretch, and the difficulty with that, as we said in our skeleton, is that you're then forming conclusions on the back of how a solicitor has drafted a particular letter, which did deal with aspects of privacy. That letter in particular, which I believe is at 118 of the bundle, just in case you need to turn it up, that letter refers to a letter that had come from, in fact, the mother's solicitors. It says, the very first thing it says is, "Thank you very much for your letter of 25th of October 2020. We don't have that letter. And this was my point to the judge. How can you cherry pick the letters that were referred to without seeing the full picture, or as we say, the wider canvas? And we say quite clearly, you cannot, with respect, do that by looking at a few letters, cherry picking a few letters and saying, oh, well, that must have been the father's priority. That must have been his state of mind. And I come to that conclusion by looking at a few letters in the bundle. With the greatest of respect, that is not an appropriate way, first of all, to deal with evidence, and secondly, to deal with coming to a conclusion that must have been a part of motivation, looking into somebody's mind. And what you would have seen as well is that in his earlier judgment on the 16th of September, the judge specifically referred to the fact that there was correspondence pre-conduct. I believe that's at 83 of the bundle. Let me just find it for you. This is the judgment, as I say, from the 16th of September. If you look at paragraph 17,
on page
83 of the core bundle.
So, sorry, this is the
judgment that the judge gave on the 16th of September dealing with the father's withdrawal application. He says here, I am told, but have not seen, that there was significant inter-solicitor correspondence between solicitors acting for the father and the mother in the months and years after N was born, and I, having not seen that correspondence, cannot decide and do not decide why, in the first couple of years of N's life, she had not been introduced to the father. So here is the judge dealing with the exact same set of correspondence over three years, saying, well, I can't decide that because I haven't got the correspondence. And yet, when it comes to his judgment in the costs application, not only does he stretch, to use your lordship phrase, not only is that a stretch, but he then uses that, I'm going to suggest, as the nucleus for his judgment. He spends the longest of his reasoning, 9 paragraphs or 8 or 9 paragraphs, specifically on that point. I say it's the nucleus of the reason he came to it. He thought there was an underlying motivator, and that posed unreasonable conduct.
But not the prime motivator.
I'm so sorry.
But not the prime motivator.
And I think it was Lady Justice Hale, forgive me, who said that most parents who come to the court generally are there for the welfare of the child. Obviously, you get the occasional parent who doesn't see that bigger picture, but that is usually why people are there in the first place. But no, not a primary.
Can I just go back to the letter that the judge placed such reliance on at page 118?
Yeah.
As you say, we haven't got the letter of the 27th of October, and I'm not going to ask for it, obviously. But do we know whether, in fact, it was simply these solicitors replying in the same order
No.
as was dealt with in the letter of the 27th of October?
No, because the point I just made
Because
to you.
that might be commonplace for a solicitor. Thank you for yours of the 8th, and sometimes they say dealing with it in the same order, but it would not be. But I'm not saying that happened, but
no, but in our skeleton we say exactly that. Is that the solicitor? What you're doing is basically looking at the order in which a solicitor has responded to a letter, which in this instance we don't even have. So it was speculation of the highest degree, and what was so wrong about it, with respect, is that he labels it unreasonable conduct on the part of the father before the issuing of proceedings, and we say that is wrong.
It's clear from the letter that whether they used specifically the same headings, this is a typical solicitor's letter responding to the letter under response. No, sorry, that sounds ridiculous, but you know what I mean.
I do, absolutely, and this was the problem. When
pick up things that have been said in the other letter and say yes or no,
and this is exactly in my submissions what I warned the court against doing, is cherry picking a few letters which wouldn't paint the full picture. And that's why we say the judge simply didn't have his eye on the wider canvas or the bigger picture, and it was wrong of him to pluck out a few letters. I think it was 3 or 4 letters that were referred to. And of course in the bundle there are other letters from the father where he specifically asks about N and what she's up to and what she's doing. And those are letters which weren't referred to because obviously they show that during the course of that correspondence there were genuine letters about when am I going to see our child? When am I going to be introduced? So the judge, I'm afraid, got a slanted picture, but more than that, he dipped his toe in the waters of arriving at conclusions that he simply should not have done. Conclusions, findings, whatever we call them, he calls it a conclusion, need to be evidence-based. And in this case, with the greatest of respect to the judge, they weren't. But that's the first branch of unreasonable conduct. There's letters in the bundle from the father about asking for parental responsibility as long ago as 2021. It was a haphazard approach, I would suggest, based on a few random letters, and certainly not the sort of evidential foundation that these sorts of findings should be made on. And in any event, even if the court decided the judge was completely right to land on that conclusion, I say it does not amount to unreasonable conduct in any way, shape or form.
It looks as if we've just been sent the letter to which that was a response, for which my lady specifically did not ask.
Well, that hasn't come from us, I'm sure. I don't know who would have sent that. Oh, it's the letter, the 25th of September 2023. The one about where the case mushroomed. It's a different one.
Oh, it's a different one, is it?
Yes, sorry.
Okay.
Sorry, my lord, that was a distraction that you didn't need at that point in time.
The timing at which it arrived floored me. All right,
I'll deal with that at the end. I'll tell you what's, because you asked for the C1A as well, and I suspect
that has come.
That's on its way if it hasn't already arrived. So that's what we say about that finding. It was wrong, simple. It was absolutely wrong and should not have been relied on to justify a finding of unreasonable contact. The other thing the judge did, with the greatest of respect, he seemed to rely on my phrase of there being flashpoints along the privacy graph line, and by that what I was referring to are the sorts of things I mentioned to you earlier, the fact there was an article and the fact that there was social media activity, all of which was having an impact on the paternal family, who had specifically asked that those not continue, because obviously there are other children involved. That is what that's what I was referring to. With the greatest of respect, that does not underpin or support the judge's decision about primary motivators and whether 4 letters equals unreasonable conduct. It doesn't, I would suggest. Just in terms of the judge looking at the conduct of all the parties, of course, that's one of the things the judge has to look at. We say that at paragraph 58 of his judgment, which is page 69, the judge specifically refers to the father's conduct. The applicable cost rules, this is paragraph 58, rules require me to consider whether father's conduct within the meaning of the CPR rule justifies a cost order, and where that conduct includes the matters set out in sub-rule 5. So there's no reference within the judgment to aspects of the mother's conduct. Certainly, in our view, that you can't find any. I think there's an oblique reference in Mr. Vickers' submission to the fact that in the transparency judgment, which of course is reported, there's a reference to the fact that there was an assertion which Mr. Wolanski described as a defamatory statement against me, that I'd misrepresented or lied to the court. I think that's what he's referring to, that the mother had in fact been, her behaviour had been referenced. I'm sure he'll correct me if I have that wrong. Of course, first of all, that's a separate judgment, and secondly, with respect, that does not anywhere appear in the judge's determination about conduct. So we say that he focused very much on the father's conduct and didn't look at the balance, which is that you look at the conduct of all parties in that respect. There was nothing in the judgment about the wholesale change that I outlined to you from September 2023. Nothing at all. And how monumental that had been in terms of costs, because of course there was definitely more preparation after the case took that pathway, and of course the father's mental health. It formed no part of his determination on the principle of costs. Neither did the fact that there were lengthy statements or that she hadn't complied with the rules. Neither was the fact that, in fact, all the way through the litigation, apart from the cost, the court agreed at every juncture with what the father was saying was best for N. Every single point, without any diversion, including, obviously, the withdrawal, including the extension of the transparency order, which, of course, was also an application made, and the court agreed that that was in N's best interests. If you go to paragraph 49, of our skeleton, but perhaps as we're on the judgment, let me take you to where there's a list. Paragraph 93 of the judge's judgment, page 75. These are the factors that the judge says he weighed into the balance when talking about the amount of costs. Now, what we say is, why is there a distinction between putting those in the balance for the amount of costs as opposed to the principle of costs? Those things that he mentions there, every single one of them, should have been in his general weighing in balance for the principle of costs. The father had made efforts before. Little b, I do want you to land on, if you will. The father was criticised and in fact labelled as having unreasonable litigation conduct. And in fact, Mr. Vickers made this submission to the court. It's in the supplementary bundle at 244. It was put to the judge that the father, having set up therapy to talk about N and how they were going to introduce her to him, and he funded that therapy before the proceedings, Mr. Vickers made a submission in court that in fact the father stepped away from that therapy. It was him that made the decision to step away because of financial matters, and he wouldn't re-engage with it unless the financial matters were sorted. as I pointed out to the judge, and as the letters in the bundle evidence and the father's statement, it was the other way round. So the father had funded therapy, they'd agreed to go, there they were, and what happened is that the mother kept introducing financial issues. The therapist, and this is in his statement, I can give you the reference for that, it's paragraphs 46 to 49 of our client's statement in the main bundle.
Second statement.
It'll be the first, I believe, but let me just double check. Yes, it's the first. 333. But 47 is where it says that the mother continually used the therapy sessions to discuss money. And if you go to the very bottom of paragraph 47, which is 334 of your bundle, you have the comments there of the therapists themselves. So you couldn't, to use the colloquialism, get it more from the horse's mouth than that. This is what the therapist said.
Sorry, what page are you on?
334 of the core bundle, paragraph 47 of the father's first statement.
Just give
So
me a bit.
the therapist starts at about line 6.
Thank you, my lord.
Is that
Indeed,
right?
indeed she does.
During our last 2 sessions.
Exactly.
Oh yes, thank you.
Thank you.
Just give us a moment, please. Thank you.
And even if you could just travel down to the next paragraph, a letter that it seems the judge attached no weight to at all, you will see that in fact it was the mother that said once everything money side is concluded, then the mother would be content to re-engage with the therapist, although the father will need to go some way to demonstrate his commitment to integrating N within the family as an equal, in particular with half-sisters, etc. And you can see at paragraph 49, financial negotiations stalled and the therapeutic work stopped. And that was another catalyst for eventual court proceedings. So what had been submitted to the judge is that, in fact, it was the other way round. It took me to take the judge to the letters to show him that, in fact, it was the opposite. So that I said to the judge on that occasion, that's the danger, isn't it, of not having the full correspondence and not looking at length into that raft of correspondence, because you don't get the full picture. And it was 3 years. So there is that point that we make in respect of that. But all of the factors at 93 of his judgment, we say were not weighed in, and they should have been weighed in respect of the principle of costs, not just the amount of costs, because all of those things there in the judge's judgment are relevant, not just to the amount of cost, but to the principle generally. So that was little b that I dealt with, and I don't intend to travel through all of those. Some of them I've made along the way, but they sound as if the judge is using them, I think he says, as mitigating factors for the amount of cost, and yet he still landed on the 75% cost order, which with respect is wrong and makes no sense. Bearing in mind the father at every point of the proceedings was chiming, or the court was chiming with what the father was saying about N. And if you look at little h, there we have it. It can therefore be said that in this sense, the father has succeeded and his approach cannot be faulted, being one that was endorsed both by Her Honour Judge Roberts and by me. Those points depressed the proportion of cost, not very much it would seem, but they should have been weighed in the balance of the principle of costs, we say, and it was wrong not to do so. So My lady, that I think deals with what we have called really the nucleus of the judge's reasoning for his decision about costs generally. But he does, of course, use other ancillary things. The next one you will find paragraph 68 to 69. This was, he says, the lateness, that's page 71 of the court bundle. Do you have that, my lady? My lords?
All I can say, if people made late applications, there would be a cost order in every case.
Well,
if that was reprehensible conduct.
Well, if that's reprehensible or unreasonable, we're all going to be in trouble. Because, frankly, that happens. I'm not endorsing it and condoning it. But the father had his mental health, as you know, it's not new. It wasn't raised just before the 16th of September. In the mother's own statement, going back to her very first statement, it's raised. In the father's first statement, it's raised. It wasn't a secret. It wasn't new. And the judge accepted that the father did have a diagnosis of depression and anxiety and had suffered with it in the past. But this was an application which found favour with the court, the application to withdraw. It wasn't some application that had been made off the top of his head, and it wasn't unreasonable. In the end, the judge agreed with it, which must show that, in fact, his conduct of that part of the litigation was fairly reasonable.
I suppose it is possible to conceive of circumstances where, viewed individually, each little chunk on its own wouldn't justify a finding of unreasonable behaviour. But when you stand back and look at a sequence, you could have that. I mean, it's not necessarily wrong in principle.
I couldn't agree more, my lord. It's you know, I think the wider canvas of the case. I mean, in this particular case, there's some attempt to paint that there was a pattern of withdrawal, which simply isn't evidence-based. But this particular application, the letter was sent on the 14th of August. That was a month before the final hearing. And in his statement, the father says he was struggling over that summer, his health, the stress of the proceedings, the anxiety, and our instructions certainly at that point were that he didn't want to step back, but he arrived at the conclusion that there was nothing else to do because it was now impacting in terms of causing harm to end, which is what one of the branches I submitted to the judge.
Well, it's a bit hard to see at first sight why this counted so badly against the father when the judge expressly says that he's not determining the reasons for the fact that the father hadn't seen the child since April.
And he says,
if he had determined the reasons, he said, I don't believe all this stuff about the father being ill, it was just manoeuvring for tactical gain on his part. Well, that would be one thing, but he doesn't say that.
no. And he says in the paragraph I think you're just reading from, he says that they blame each other. So that the parents blamed each other about why that hadn't got back off the ground.
Well,
and he
as
didn't.
a non-family lawyer, I can see that that's not unusual.
No, but as a family lawyer, I can tell you it's definitely not unusual. But certainly, my lord, you're absolutely right. He didn't traverse those issues. He didn't trespass on making findings about those, and yet he held that the father's conduct in a number of ways was unreasonable. And he uses.
Which paragraph was that?
That was 69, I think. Hold on.
60.
Yeah, sorry,
Yes.
68.
68, sorry,
That's what I
yes.
was looking at. Lovely, thank you.
So there's that in terms of that. The other reason that the father is criticised is he didn't agree to the section 9114 in September, but he did agree the day before. My lady will know, my lords may not know. It is a common thing at the family court for people to turn up even on the day of a final hearing and agree with what is being said. It should not be held against people as unreasonable conduct. It is common for, on the day, with the advice of lawyers, or to find a way to digest perhaps the recommendations of an expert. But if we are going to start saying that people coming to court a few days before and conceding an order is unreasonable conduct, then I fear we are headed into very choppy waters. That is not unreasonable conduct.
And as if I understand that, on one side of the choppy waters, it's because it could act as a chilling effect on settlements. concessions. On the other hand, it must be possible, again, I'm only really dealing with the realms of possibility, that someone does string the other party along for bad reasons, and in such a case there might be the beginnings of a foundation for an adverse costs order, but you'd need to express the finding of fact.
You would. That was my point in
don't
response. What the judge did not do is align himself with the mother's case that that's what was happening here, that everything was a form of litigation abuse, and that it was done to, as you say, you know, not string people along, but it was done with a view to keeping the pressure on and not conducting the litigation properly. The judge did not make that finding. He would not align himself with that assertion.
Could I raise another point which you may not want to deal with at all, or you may not want to deal with it now, but can I just raise it so it's
Yes, of course.
when deciding whether to exercise the discretion to make an adverse costs order or as to the amount, is it a material consideration that the conduct complained of has or has not led to an increase in costs? And then I know enough to know that this is said to be a punitive jurisdiction. But if you have a course of conduct which is thought to be unreasonable, but it hasn't increased the costs at all, what's the justification for making an adverse costs order?
Well, what the authorities say is that unreasonable conduct or reprehensible conduct opens the door to a costs order, but the court, in exercising its discretion, doesn't have to make a costs order. So even if you've got an unreasonable course of conduct, that doesn't necessarily equal there's going to be a costs order. So, and particularly I would suggest in a case where the costs haven't been dented or increased at all.
Because we've got no, I don't know whether it was raised in the court below. There's no consideration in this case by the judge as to what difference it's made.
No consideration at all, and the converse is there's no consideration of what the pathway of the litigation in September 23 did, and that's where another way I suppose the judgment falls down and is wrong, and that's the point. He didn't get the balance and exercise right. He didn't put the right things in the melting pot that would then require him to arrive at the conclusion he did, and the examples he used of unreasonable conduct, we are saying, are not examples at all. I don't know if that answered your question, my lord. I hope it did.
Well, it went about 2/3 of the way to answer it.
Well, then I'm pleased to have done that because I travelled some of the way. Just finally, I'm coming to the end. You'll be very pleased to hear. You will see, and this is at paragraph 70 to 77 of his judgment, at pages 71 to 73 of the call bundle, there is a definition, a finding, that the father not attending remotely or otherwise on the 16th of September and the 25th to the 26th of February amounted to unreasonable conduct. Now, I hope I don't have to spend too long on this, but in his application to the court in September 2022, it says in terms that because of the geography, he is going to have to attend remotely. That was there, and all along the way, not one judge raised any issue. But what our client did, even though he'd filed that application, which certainly by the time Her Honour Judge Roberts came to deal with it, she knew the geography and knew why. He specifically made an application for every hearing if he wasn't able to. So he actually issued another application just to make sure the judge was sure.
And we're talking about the other side of the world.
Yes, the other side of the world. And so here we are on these two particular days, and he attended, January 23 was vacated, 18th of January. April he attended in person. That was in 2023. November 2023 he attended remotely. So he was there on that. It said somewhere about he didn't, on the 3rd of June he didn't attend. Yes, he did. He was on screen on the 3rd of June. I asked at 2:26 p.m. when we went back in court, Dr. Proudman and I, before Her Honour Judge Roberts, when we were going through the draft order, would she mind, as it was 3:20 a.m, if my client didn't join for me going through the draft order? And she said, it's at 204 of the supplementary bundle, I believe, that's fine, Miss Brereton. So it's not right that he didn't participate in that. The only hearings where it became an issue were the 16th of September and the 25th, 26th of February. And you will know that it was said and medical evidence was produced on the morning of the 16th of September. The father had had an anxiety attack. So this wasn't tactical. There was nothing to gain by not being there. I was fully instructed in terms of the permission to withdraw application and the costs and the section 9114 had we got there. I was fully instructed. So it wasn't going to derail the proceedings. There was no impact by virtue of his absence. But again, if we are, and the judge didn't make a finding about that, but the judge alluded to the idea that Mr. Vickers had raised that, well, if it's a private GP, you know, they'll be a bit more sympathetic to giving you a letter, which I have to say, if that's what this is based on, really is quite appalling, because what was being suggested is that private GP had just signed him off, but there was a history. The father suffers from depression and anxiety. He's on medication for it. That hasn't changed. And here he was. And again, I remind you that in the build-up to that 16th of September hearing, the allegations had ramped up again. And I took you to that one earlier, which on any assessment is a significant allegation, which came in the mother's statement on the 28th of August. A day later, it might not surprise you that a day later the application was made. So, but if the courts are now saying that if people don't turn up and they've produced medical evidence that really that is unreasonable conduct when the father had attended the other hearings and I was fully instructed on all issues, then I fear, again, we are treading into quite dangerous waters.
Well, you say that there's a conflict between paragraph 74 and 75, because in paragraph 74, the judge says I must be careful not to go behind the medical letters, and then that seems to be exactly where he goes.
What he did. Exactly. On the basis that private GPs are more sympathetic to giving you, false or fake letters. He says he doesn't go along with that, but he clearly, his thoughts and reasoning and logic there is underpinned with the idea that it's just something that's been done at the last minute to get out of attending. But there was nothing tactically to be gained. The father's mental health has significantly suffered during the course of the proceedings. And so we say that really cannot and should not be classified as unreasonable.
I don't understand 75 either, because there was no question of the father seeking an adjournment. He wanted this over.
100%. In fact, on the 16th of September, he had thought it might very well be dealt with because the permission to withdraw was in section 91. It had gone off again for a few months, and there's no criticism the court gave us, obviously, because the judge is a deputy High Court judge, not sitting full time. But there were these points that were made, and I don't think the judge aligned himself with all of them, but there was nothing for the father there to gain. And as I said, the only issue for me was fluidity of instructions throughout the day. But there weren't any, because the issues we were dealing with, I had full instructions on, and the judge was able to deal with it. The mother didn't make an application to adjourn, and you're absolutely right. That was dealt with, and the case brought to an end. And the last thing, of course, that he uses is the late statement. Again, this is on the, I'll deal with it, but it's on the transparency side. This wasn't a statement dealing with the Children Act proceedings. I should make that clear. It was a statement dealing with the statement the mother had filed in the October in accordance with directions regarding the extension of the transparency order. I mean, all I can say about that is that it was sent in advance, 2 weeks in advance. The mother didn't seek to respond or prepare a statement, but it was agreed that if the statement went in, there were a selection of documents that she wanted, which everybody'd seen. So there was collaboration about that. The media parties did not oppose that statement going in. That doesn't mean that the judge has to allow it in, of course, but just so you know the flavour of what that statement did on the day, and the fact it had been served previously. But ultimately, we say, again, that is not unreasonable conduct, and in any event, the judge didn't allow it in. And any costs, I think to be fair to the judge, any costs he said would not have been significant anyway in dealing with that, and that's what we say. And then finally, I think, and unless I turn my back and I've completely missed something out, is the idea, and it's not a point I push very far or at all. I think what the judge thought I was doing when I took him to examples of authorities on unreasonable conduct was trying to restrict the boundaries of the jurisprudence and giving it too narrow an interpretation. Can I make it clear that the band, the discretion is wide, of course, cost orders can be made when just. What I was doing is showing him that the authorities across time, even before Lord Justice Peter Jackson's authority, re-E last year, the cases where unreasonable conduct is, where conduct is held to have been reprehensible or unreasonable, really are in different territory. That was simply the point I was making. Of course, this judge took a different view. I wasn't trying to put, as Mr. Vickers describes it, an impermissible gloss on it. There was no real, interpretation by me that he couldn't do that. But what I say is, if you look at the cases in the round, and I accept every case is fact specific, the sorts of things that cost orders are made for in the authorities, which are in the bundle, are things like people fabricating sexual abuse allegations, people not complying with the expert advice of 2 psychiatrists and forcing a trial. And also in re-E, you will remember that in fact in that case there was allegations that the father had exposed the children to a sex ring. These are the sorts of territory, but I say no more than that, m'lady. The judge thought that my interpretation was too narrow. I just don't want it misconstrued. What I was doing is trying to say these are the sorts of examples which don't fall in line with what we have here. That was the only reference that I was trying to make out of referring to those authorities. M'lady, may I turn my back for one
Certainly.
moment?
Anything else?
M'lady, if I may, and you'll remember the Lady Chief Justice's words about giving our juniors a voice. In fact, the 2/3 that I got to, I think my junior would like to see if we can get all the way in response to your question, my lord. I don't know, m'lady, if you'll oblige for a moment, but I will sit down and be quiet.
Yes, Mr.
Thank you, my lady. I'll do my best to get us to the full 100%. I think, my lord, your question was directed at really the causative link between the conduct that is found, albeit our primary submission is that conduct doesn't meet the threshold of unreasonable, and then the costs that were incurred. And so we deal with this, albeit in a brief reference, at paragraph 64 of our skeleton at page 37 of the core bundle, in relation to what we say was the judge's failure to segment or to look at the different phases of the litigation and how, if there was a finding of unreasonable conduct, how that related to a particular phase. So we say there was a failure to segment or calibrate the costs order in respect of that conduct. And drawing on what my learned leader has just said, of course we accept the discretion in this area is wide, but where there is that discretion against a backdrop of these orders being exceptional, that discretion should be exercised with precision. And we say that didn't happen in this judgment, because we have the findings that my learned leader taking you through, or the conclusions as to unreasonable behaviour, without any interrogation as to how they then impacted on the course of the litigation. So the nucleus or the backbone finding as to motivation, that of course comes in the pre-proceedings period. So it's quite difficult to see, and without the benefit of a crystal ball, what would have happened absent, if the judge is right that that was a motivator, absent that motivation. So it's sliding doors moments, if you like, in relation to points in litigation where different routes weren't taken. And we would say, given that field, given the discretion that is afforded, but against these orders being exceptional, there should have been a look at, in each instance, each conclusion, what has this impacted upon? So are we having more hearings because of the father's non-attendance? Well, the answer to that was no. They carried on. My leader had the instructions, etc. Did it derail hearings where there was a late application or a late concession? Answer, no. So those are the points, I think, perhaps in a civil context, and I defer, of course, to my laws on that, but it's far more common to have a costs order that relates to a particular issue, and it's obviously far easier and perhaps a binary context to say with a win or a loss on a particular application that the costs can be wrapped up. But even so, with the less linear and wider course that these proceedings take, we say there should have been some interrogation of those costs.
I think you would rephrase my question and improve it by saying it is a material consideration whether the conduct complained of has or has not had an impact on the course of the litigation.
Yeah.
And leave it as general as that.
Thank you.
I think that goes 100% of the way.
Excellent. Thank you very much, my lady. Unless, my lords, there's anything else at this point.
For me, thank you. Thank you very much indeed, Miss Brayton, and you, Miss Sheridan. Yes, Mr. Vickers.
Thank you, my lady, my lords. My lady, my lords, as you know, I appear in this matter on behalf of the respondent, mother, Miss Nervo, unattended by my junior, Miss Burrican Jones, who appears on a pro bono basis.
I'm very grateful to you. Thank you very much.
I know
Miss
my
Burrican
client
Jones.
echoes those sentiments. My lady, my lords have already indicated that you have read very well into this appeal, and therefore
Yes.
I don't intend to rehearse much of the background or detail. You've heard much of that from the learned friend for the appellant.
And we've read, of course, with great care, your skeleton argument.
I'm obliged. I am, however, also obliged to set out, I think, at the start of my address, that this is an appeal, self-evidently, against a costs order, and it is an appeal which we submit discloses no error of law. Indeed, it's not put in that way. It is put on the basis of an error in the exercise of discretion. We say that the exercise of the judge's evaluative discretion fell well within the bounds of what was permissible to him, having regard to the evidence and material before him. We also submit that this being an appeal against the costs order, to borrow from the language of the case law, this is a case beset from start to finish by the heavy burden faced by any appellant who seeks to establish that a judge's exercise of discretion at first instance falls outside of the discretion conferred upon him. And that is important for a number of reasons, which I will come to in due course. I will make 3 points. The first, happily, you will, I'm sure, agree I will take very succinctly, which is to outline the correct appellate approach to costs orders in Children Act cases. Second point is to set out why the judge was plainly entitled to depart, in this case, from the no order principle on the facts. And thirdly, why the pleaded grounds disclose in our submission no error which gives rise to substantiating this appeal. Can I start with the law? It is well settled, and as you know, Nicholas Allen KC, sitting as Deputy High Court Judge, adopted my learned friend's note on the law, with which I agreed. And it is also agreed that that note was applied in this case. There's no suggestion made by the appellant in this case that the law was misapplied. There is, however, in the authorities a curious mixing in my submission of the words exceptional and unusual vis-a-vis the making of costs orders in Children Act cases and the circumstances in which it is appropriate for the court, or circumstances in which the door will be open to the making of such an order. My Lord, Lord Justice Peter Jackson, of course, in Re, the most recent occasion upon which this court has considered the point, refers to exceptional cases as being those cases in which costs orders might be made, and I emphasise might. Whereas when one winds back to the Supreme Court authorities, and particularly Lady Hale, in 2015 case of Ries, and that appears at Authorities Bundle page 67. Uses the more apposite verbiage of unusual.
Paragraph.
And if I may,
In the headnote, it's at 68, letter G.
thank you, Lord, I'm fine. And just to underscore the point somewhat further, if I may, if one looks at the authority of C versus S costs, 2022 EWC 80, which appears at Authorities Bundle page 87.
Just pause a second.
Certainly.
Thank you. Sorry.
Thank you. The case report begins at 87. I would like you to turn the page, please, my lady, to page 88. And just below line D, you will see that the grounds are summarised. Ground 3 in that appeal was that the judge at first instance, Her Honour Judge Satnara, who is now the incumbent, so I understand it, judge at the Central Family
Yes.
Court.
Sorry, am I looking in the right place?
Page 88 of the Authorities Bundle,
Yeah.
just below D, in the margin.
As for ground 3.
As for ground 3, the judge had used the word exceptional when she should not have done, but this was a slip of the tongue.
Well, that's High Court, and we've had Peter Jackson since then saying exceptional. So
Well, but you have Lady Hale in the Supreme Court saying unusual. And my simple point is this.
Tell us the difference.
Yes,
thank
certainly.
you. That's just exactly what I was going to ask.
So the difference in my respectful submission is that that which is exceptional is always unusual. But that which is unusual is not necessarily always exceptional. That is the distinction on an ordinary application, an ordinary interpretation of those words. And so the vernacular is important in my submission because the use of the word exceptional, where in my submission it ought to be unusual, runs the risk of
So you want us to overturn Peter Jackson in this respect?
No,
and
I
say that
want
he
this
was
court
wrong
to-
in law.
No, I want this court to follow Lady Hale.
No,
in the
but that
Supreme
will
Court.
require. But you want us. That will necessitate us saying that this is not just a semantic difference, but that it is a core difference to the whole approach to costs, and therefore Peter Jackson is wrong, and the court should use, for the reasons you say, the word unusual.
My lady, my submission is that the correct test.
No, but could you answer my question?
Yes, certainly. Yes, I say that it was wrong to use the word exceptional.
Is it ratio?
My lord,
Can we just look at Peter
if we look at, yes, we can look at the authorities at page 151 of the bundle. The authorities bundle, that is.
Thank you.
Page what?
So it's page 159,
Thank you.
paragraph 23 at C in the left-hand margin. there is a general practice of not awarding costs against a party in family proceedings concerning children or retains the discretion to do so in exceptional circumstances. That's where it first arises.
And that's where you want to say he's wrong in law.
That's where I say he should have used the word unreasonable.
What difference does that make to the outcome of the case, in that case and in this case?
My lady, it doesn't necessarily make any difference to the outcome in this case, because
Why are we going down there then?
Well, my lady, because it's being suggested that it wasn't open to Nicholas Allen KC to find that the conduct of the appellant in this case fell in to the bracket of exceptionality.
No, I'm sorry, in that case I've wholly misunderstood, because I understood what Miss Brereton's, the foundation of her appeal was that that the case, that on the facts of this case, it could not be said that the husband's behaviour was reprehensible or unreasonable. Now, actually, if you don't get that sort of behaviour, what does it matter whether ultimately it's exceptional or unusual?
Well, my lady, I'll move on and meet that point.
But am I right? I mean, I think that's how Miss Britton's put her case, isn't it?
Well, my lady, I'm getting an offer from Miss Brereton, so I will take it.
But I think we've all been listening.
Yes.
In the area we're dealing with, what is said to be either exceptional or unusual is reprehensible and unreasonable conduct. So ultimately, that's the test which has to be applied, and that's what the judge, you say, did apply.
Yes, my lord. So
Brereton says you got it wrong.
my lord, yes. I'll move to the matter in hand and the grounds then. It is important in my submission that this court acknowledges that this judge had conduct of this case beyond the hearing in February, which gave rise to the costs order. He had a good, detailed knowledge of the factual background and of the circumstances that had led matters to February.
Yeah.
He had produced two judgments, the transparency judgment and the cost judgment under appeal. He had produced an extemporary judgment as well from September dealing with the application to withdraw. So in my submission, it must be right that it is acknowledged at the outset, I don't think it's being suggested otherwise, that Nicholas Allen KC was very well placed to grapple with the factual matrix in this case. And we say that he did so admirably, clearly, and well within the exercise of his discretion. The grounds of appeal in my submission could be grouped. So I'll take 1 and 3 together, if I may.
Of course.
Those are challenges to the exercise of discretion. It is suggested on behalf of the appellant that Nicholas Allen KC was wrong to find or evaluate that the respondent's conduct was unreasonable, such that it opened the door to the making of a costs order. And in advancing that submission, in my response, I submit that the appellant invites this court to adopt and apply a narrow focus to the individual limbs of behaviours as found by Nicholas Allen KC, which gave rise to his ultimate conclusion that the appellant had behaved unreasonably. In doing so, they fall into error because the task of the judge is to step back to assess what is often called the wider canvas and not to focus individually on the specific acts complained of and relied upon, but instead to determine, within the exercise of discretion, whether the sum total of those individual matters cross the boundary into that which is unreasonable, giving rise to a costs order. I think my lord made the point earlier that it is conceivable, at least theoretically, for individual matters taken in isolation not to reach that threshold, whereas a combination of such matters is capable of doing so.
In which part of the judgment do you say the judge did step back and look at the accounts? Can you show a paragraph where he did that?
Well, my lord, I will answer that. My first observation is, of course, the judgment has to be read as a whole. That is trite submission to make. But what Nicholas Allen Casey does in my submission is that over the course of several paragraphs, it's 59 of the core bundle, paragraph 57, through to paragraph 86, frankly.
Sorry, 57, did you say?
Yes, my lady.
Well, that's the chunk that Miss Brereton took aim at.
Yes, it is.
Went through each bit of it.
It is,
But her submission is that, in fact, at every material moment, the conduct of the father has been upheld by the court, whereas Appellant.
well,
That's a fairly holistic, I hate the word, holistic overview, hate that word too, of the whole case, isn't it?
It is, and so that is, I'd understood my lord to be asking me where the judge takes a holistic overview.
Yes, I thought your submission was, well, it's okay for the judge to look at these various individual items, the order in which things are put in the letter, the fact that he didn't turn up to the hearing and so forth. But what he's got to do is step back and ask himself, does all this as a whole amount to unreasonable conduct? And I thought you would, as you'd submitted that was his task, I thought you were going to show us where he'd done it. But you just refer us to the whole of his determination.
Well, that, my lord, with respect, that is where he sets out the various factors.
Okay, well, I mean, if that's
to the conclusion, and that is my submission.
If that's your answer, that's your answer.
That is my answer, my lord. What I would address squarely is the submission that because it is said the father, the appellant, was successful in persuading the court at first instance of his position.
Can we not use the word persuading? Because
Certainly.
submissions were made.
Indeed.
And the judge heard both sides, very skilled specialist counsel on each and every occasion, often silks,
Yes, my lady.
and made a determination.
Yes.
And persuading sort of rather undermines the judge,
Well,
especially a designated family judge of the experience of Judge Roberts.
Certainly.
I don't think she would be easily persuaded. I think she'd listen to submissions and reach a determination.
My lady, it certainly wasn't my intention to.
No, I know you didn't mean any
cast it in
discourtesy,
that
and
way.
I saw it elsewhere being used, the word persuasion.
Certainly.
Perhaps it goes into the category of my lord's words we don't like.
Noted, and it will not be one that I repeat. my lady, then not persuade.
Okay. Oh, my lord, I think, has got a few he'd like to add.
Perhaps my lord could give me a list after the hearing.
I'm sorry, I didn't mean to interrupt.
No,
Mr.
not
Vickers.
at all, not at all, my lady.
Do go on. So,
The point I wish to make here is that simply because the father succeeded in withdrawal of his application does not, and this was a submission made and indeed accepted by Nicholas Allen Casey in the court below by me, does not axiomatically mean that it cannot be said that his behaviour vis-a-vis the conduct of proceedings is unreasonable.
now help me on this, because task being stepped back, I hear what you say about that particular application, but when I've been doing my preparation for today, we've got what was clearly a completely misconceived application for a declaration of parentage. we've got the finding of the application for the finding of fact. We've got the disguised further application for a finding of fact. We've got the challenge to the withdrawal of the child arrangements. We've got the opposition to the extension of the transparency order. Each of those were fought. Each of those incurred substantial costs. And on each occasion, whichever judge it was, found in favour of the application made by the father.
Yes, my lady.
So I think it's not helpful to put it that simply because he acceded on the withdrawal, then we have to disregard the fact that the father has succeeded.
No, I'm not inviting the court to disregard the fact that the father has succeeded. What I'm asking the court to do, and which I say Nicholas Allen correctly did, is to separate out the fact of the father's success in relation to those discrete aspects of the litigation from consideration of whether he had behaved reasonably. And the way in which I say it's appropriate to do that is because success, to use that vulgar expression in the context of private law Children Act proceedings,
I understand the context you're using it in.
it is not in my submission to be measured by reference, as I submit the appellant would have it, to the last application made late on the finding of Nicholas Allen KC to withdraw. It is to be measured by reference to the originating application which brought the matter before the court in the first
You can't
instance.
ignore all the middle bit.
Well, no, you can't. And Nicholas Allen KC did not ignore the middle bit. He traversed it and knew it very well and demonstrated that in his judgment. But this is not one of those classic cases where a party sees the writing on the wall in the form of expert evidence, be that from an independent social worker or a psychiatrist, that provides a negative prognosis for the success of their application and withdraws in those circumstances. This is not that case. This is a case where, as my lady has already observed, rather curiously and unfortunately, notwithstanding everything that had transpired, the parties were, at least until the point of the father's withdrawal, and indeed post his application for withdrawal, all saying that contact between the father and the child should continue. So this is not one of the cases that appears in the authorities manual. I think it's the first case that we have where the mother in that case was criticised for pursuing a case as against the weight of evidence. The judge says you should have come to that conclusion much quicker. This isn't that case. This is a case where the father, in my submission, causes this mother to incur £500,000 of costs in responding to an application for a child arrangements order. And then at the 11th hour, without proffering any reason beyond his declining mental health for not taking up contact, he withdraws that application in the face of the mother saying, I want N to spend time with you. I want N to see you. And his actions in the litigation have to be set against, in my submission, the context of his engagement with the orders that the court was making. If I can illustrate this point by taking my lady in the bundle, it's the supplemental bundle. It's the order of Her Honour Judge Roberts, dated 3rd of June 2024. It's at page 38 of the supplemental bundle. And the relevant and operative part of the order is at page 40, paragraph 6. The court made an interim child arrangements order. There was no, as I understand it, and you'll appreciate at this stage I was not engaged in the matter, there was no dispute as to the principle of there being contact between the father and N at this hearing in the making of an arrangements order. As I understand it, the issue for determination, on which Her Honour Judge Roberts ruled in relation to was the duration of those periods of contacts. But there they are set out: 29th, 30th, 31st of July, dates in August, dates in September. And this court knows that the father did not avail himself of any of those contacts. Now, if that was a mother failing to make a child available for contact, the court would have no compulsion, in my submission, in forming the view that defiance of a court order of non-engagement with a child arrangements order falls very easily into the category of something that is unreasonable.
Just result in a costs order.
What, if taken in
And
combination...
where do we see the analysis in the judges of the father's statement where, rightly or wrongly, he references that to his failing mental health and offers his profound apologies for not having taken up the contact?
Well, we also see, of course, my lady, in the judgment.
But is your submission that where a person who is suffering significant mental health issues such that they're receiving pharmaceutical treatment, who fails to take up their contact, should be regarded as reprehensible, leading to a costs order? Is that your submission?
My submission is that the evidence before Nicholas Allen KC, and it's referenced in the judgment, is that the father told the independent social worker and then further reiterated that he hadn't given much of a reason at the time of not taking this up.
Yeah, well, he should have done, and I feel, you know, the poor mother kind of trying to organise this, but this happens all the time in private law cases. People, it's a jungle, it's a nightmare, it's so difficult in private law cases. I feel profound sympathy for the mother who was trying to negotiate this and prepare her child for contact. I completely understand that. That's very different from saying that contrary, you would say, the unusual circumstances, it should lead to an order for costs.
Well, but my lady, I don't resolve from it. I say that not taking up the contact which you have asked the court for, providing no reason on your own case, no good
It's
reason.
punitive costs, isn't it? Because it's not actually it's not resulted in any money.
No, but I think I make this point
So
in my
it's
argument.
punishment.
I say that the way that the jurisprudence has developed in the context of children cases, that the cost jurisdiction is punitive because it relies upon unreasonable behaviour or reprehensible conduct.
So not, just so I've got my note right, so
Yes.
not taking up contact should lead to an order for costs, notwithstanding it had no financial impact.
On the facts of this case, my lady, the not taking up of contact in combination with the withdrawal of the application after over 2 years of litigation justified Nicholas Allen KC concluding, in the exercise of his discretion, that the door was open because the appellant's conduct was unreasonable vis-a-vis the litigation. That is my submission.
Thank you.
Do you accept that the not taking up the opportunity for contact had no impact on the costs of itself?
In terms of the legal fees incurred, my lord, I think I have to accept that. My lord, I would, in anticipation of having the opportunity to respond to the point my learned friends junior addressed you directly in relation to, in my submission, the jurisprudence in this area in terms of costs of Children Act proceedings reveals that there is not necessarily the causal link that one sees in other jurisdictions between an increase in costs and the conduct complained of.
I didn't put it quite like that.
No,
And the response that one looks at the impact on litigation steered me away from what might be thought to be my natural territory of causation. So I'm not pressing that. That's why I asked you about impact on the costs. Thank you.
that's fine.
My lady, is there anything else in relation to the first and third grounds?
No, that's very helpful. We're very clear about your submissions on that.
Thank you very much indeed. Can I then?
So which ground are we moving to now?
Yes, certainly. My lady, can I then deal
I think
with?
you may have already dealt with effectively ground 2, haven't you?
Well, my lady, I just want to deal with one aspect of ground 2.
Of course,
It
deal
arises-
with whatever you
Yes,
whatever you like, Mr. Vickers.
Thank you.
It was simply that I felt it had morphed. It's sort of been included in many ways when you'd been telling us about standing back and looking at the totality.
Indeed, thank you.
Ground 2.
Yes, and this addresses the decision regarding motivators being flawed and derived from limited and selective correspondence. I'm not going to repeat the points made in my skeleton argument in relation to the way in which that material had been placed before the court.
We have your submission.
Thank you. But in my submission, it is entirely appropriate and within the normal purview of a judge at first instance to undertake an evaluation and form views from documentary evidence, having heard submissions. There is nothing alien or inappropriate or procedurally irregular in my submission about that. And so I do not demur from the submission that Mr. Nicholas Allen KC was entitled to consider those letters to which you've already been referred and to which I'm not proposing to take you back to unless you wish it into account and consideration. Can I squarely address the issue in relation to the point raised by my lord in relation to paragraph 65 of the judgment of recorder of Mr. Nicholas Allen KC? It's at page 71 of the core bundle. And the point I think raised was whether in expressing himself as he did in that paragraph,
Paragraph 68, I would
65,
Sorry,
my lady,
yep.
forgive me.
beg your pardon. Yep.
Whether expressing himself in the way he did in that paragraph, that the judge was finding or making a finding or purporting to make a finding that the father was primarily concerned with C's welfare. In my respectful submission, that is not an interpretation that I think is open on a proper reading of that paragraph. What is clear from that paragraph is that Nicholas Allen KC rejected my submission in the court below that privacy was the primary motivator. But he did not go as far as to find that welfare and a desire for a relationship with C was the primary motivator. To put it in other words, in my submission, all that can be deduced from his expression in paragraph 65 of the judgment is that both were considerations, neither enjoying primacy over the others.
What makes, if you're looking at the judge's reasoning there, paragraph 65,
Yes.
what makes for a finding of unreasonableness? Is it the requiring a confidentiality agreement to be signed as a precondition of a financial offer? Or is it requiring a confidentiality agreement to be signed as a precondition of a financial offer when part of your motivation is to protect your privacy rather than with the welfare of the child?
It is the latter, my lord, in my submission.
So just say that
So
again.
even if it's a subsidiary motivation and the primary motivation was welfare of the child, the subsidiary motivation is sufficient to convert conduct, which otherwise would not be reprehensible into conduct.
Forgive me, my lord. Forgive me. I've misunderstood, and the fault is entirely mine, my lord. That is not my submission. It is not that a subsidiary motivation for privacy would convert a reasonable motivation, an ordinary, to use mine.
Reasonable action.
Indeed, would convert it to an unreasonable. But on the facts of this case, taking the totality of the evidence and the broad canvas before this judge, he was entitled to consider this element of the case and then look with the benefit of hindsight at what the appellant ultimately walked away from this litigation with and come to his own conclusions and evaluation about motivators from that, because we all know that what the appellant comes away from this litigation with in real terms is a transparency order and a section 9114 order.
No, I'm sorry, and no order on the basis that contact will be agreed between the parties. And the Children Act requires that the no order principle.
Well, my lady,
The fact that contact may or may not happen, but it was agreed between them that there would be contact. And I think the father, was he suggesting 4 times a year and mother was suggesting once a month?
that's correct, my lady.
So to say that he walked away with nothing other than a transparency order,
Well, my lady, in terms of
Is
orders,
not right.
In terms of, I was referring to orders. In terms of orders,
no, but one hopes at the end of at the conclusion, very often one hopes that you're going to be able to achieve no order. That's what you aim for. It's what the Children Act says you've got to do.
Well,
So the fact that there isn't an order,
well,
you know, if there was an order saying he wasn't even going to have indirect contact and that was that, then absolutely I would agree with you wholly.
my lady,
Position.
the father's application wasn't a C100 asking for the court to make no order on the basis the parties would agree. The father's application was for the court to make a Section 8 order, and he did not achieve that. He withdrew that application, did not pursue it.
That again would be very common, because if there can be agreement between the parents, there's going to be contact arranged on an informal basis between them, then you would withdraw your application for a Section 8 order. I know that wasn't his motivation in this case. I understand that.
Yes.
I'm just concerned that you would suggest that he was left with nothing.
Well, my lady, in terms of an order for contact, I don't demur from it. He was left with no order in respect to contact. And in my respectful submission, it's more usual, in fact, in circumstances where parties agree contact, that they leave the court with a consent order reflecting that, rather than an order that says they will simply agree and there being no order.
But you're saying this makes him unreasonable or reprehensible.
I am saying, my lady, that one can only evaluate, as Nicholas Allen Casey did in this case, the conduct of the appellant measured against the yardstick of unreasonableness at the conclusion. And one can only then look at all of the constituent parts of that conduct through that prism to determine rather whether or not it reaches the threshold of open the door to costs. At the time of an individual decision, it may be that it isn't unreasonable at that moment, but my submission is that the judge was and is entitled to consider, step back, look at the broad canvas, look at the history, look at the trajectory of the case, and consider that at the end, those individual matters collectively reach the threshold of unreasonable conduct.
Thank you.
As to the last ground 4, I'm not certain. I'll invite the views of my lady and my lords as to whether or not the misunderstanding is mine or otherwise. But I hadn't understood that ground to be really pursued with any vim or vigour in the submissions made by my learned friend for the appellant, because, of course, the first point under that ground, in terms of the skeleton argument, is that the case did not fit squarely into the structure of cases in which behaviour is deemed to be unreasonable. And I'd understood my learned friend's final words before giving way to be that she accepted that there was flexibility in these matters. I think that the use of words such as squarely into the structure of such cases is rather unhelpful. It really goes to the point that my Lord Justice Peter Jackson made most recently in Re, that the rule as far as costs is concerned in children act proceedings has to be flexible and meet the justice of the individual case.
Sorry, ground 4 was about the mother's alleged litigation conduct.
Forgive me, I'm looking at, so ground 4 in the grounds, yes, I was looking at the skeleton argument, which only, forgive me, I should have signposted that better.
Sorry,
No,
the skeleton argument.
The fault is mine. So ground 4 of the skeleton argument, you'll find it, the core bundle, and it's page 36.
Oh, that's why I was confused.
I apologise, my lady.
Yes, well, that didn't time with ground 4 as drafted.
So, my lady, my lords, unless there's anything in relation to that particular ground you wish me to address.
Well, I think if I'm just looking at ground 4 as is the grounds of appeal,
Yes.
I think the point made in the short point in that was that the judge said he was going to consider the father's conduct, and the rules specifically say both parties' conduct, and that a very significant step change happened when Dr. Proudman was instructed, and as my lord put it, the case went mute, and that should have been included. I'm not saying that's right or it's wrong. I'm just saying that I'm under my
Yes. Well, let me meet that.
So I think brief submission on that would be helpful.
Certainly. The first submission I would wish to make as far as that ground is concerned, my lady, is that, of course, in the context of an application for costs being made by the respondent against the appellant, the judge was necessarily going to be looking more keenly at the conduct of the appellant rather than the respondent, because it was not being said by the appellant in the court below that the respondent's conduct was unreasonable, such as to give rise to the making of a costs order against her. In relation to the sea change, in my submission, the appellant...
Hold on, not saying a cost order should be made against the mother, but you're not saying, are you, that the mother's conduct, and in particular the sea change in the way the litigation was run, was not something which the father relied on?
No, the rules plainly set out, my lord, that the court has regard to the conduct of both parties.
The submission was made to the judge, and if you look at the father's conduct, look at the mother's conduct too, as I understand it. Yes.
Yes, my lord. But what I am saying is that in the appellate context, when one is looking at a judgment, even a written judgment, one has to consider the applications that were being advanced. So necessarily, because the judge was considering an application for costs by my client, the respondent against the appellant, he would necessarily have a greater focus in terms of explaining his reasons on the appellant's conduct.
Well, a greater focus, but where do you say the judge dealt with the mother's conduct?
Certainly. My lord, if we look at the judgment, which, as we know, begins at page 59 of the core bundle. Yep. Page 75. Paragraph 92.
That's a man after he's already decided.
My lord, if I can develop the point. No, not at all. Paragraph 92, the factors I've taken into account in deciding whether or not to make a cost order are also relevant to determine the amount of costs. It is clear from the fact that by Rule 44.43a, the court will have regard to the conduct of all parties, including in particular matters I have considered above. So
wait a minute, including the matters considered above. So where do we see above the consideration of the step change or the sea change?
My lady, I cannot point this court to a specific part of the judgment where that is done, but this court will well know that judges at first instance are indulged to the extent that it is taken that if they refer to a rule, that they have considered it and they have applied it. And in my respectful submission, whilst the structure of this judgment may be unfortunate in the sense that these matters only come after the judge has expressed his decision on the principle, that this court should not engage in a forensic textual analysis of the judgment, such as to elevate that to a determination that the judge fell into error, because he was plainly aware of the rule, plainly aware of the need to consider both parties' conduct.
Therefore, we should assume that he has, in fact, although he doesn't say anything about it.
Particularly where he is exercising a discretion, yes.
And what weight do we say? What weight do we assume he would put on?
Well, weight to the extent that he applied a 75% reduction when assessing the application for cost.
I mean, I don't want to be offensive, but so what? What does that tell? This court is looking at a submission that he has failed to take into account her conduct when deciding whether to make a cost. You can't, as you frankly acknowledge, you can't refer us to anywhere where he does that. Your submission is that, as I understand it, that because he's at some point said he's meant to do it, he's done it. What I'm asking about is, what is this court meant to assume or find was his reaction to the mother's conduct?
Well, my lord, this court should assume that because Nicholas Allen KC referred to the rule, that he was cognizant of it and he applied it. But can I take this one step back, which is this notion that the mother's renewed application for a fact-finding hearing is a sea change and that is conduct that is unreasonable. That's not actually a finding that the judge was invited to make or made in the court below. So if we're talking about looking at the mother's conduct in terms of her application, renewed application with Dr. Proudman for a fact-finding hearing, Ms. Brereton can't point this court, because it doesn't exist anywhere where the court decided that that was unreasonable.
Yeah, but it had a massive impact on the costs.
But that is not the same, my lady, as being an unreasonable position to take. And that is why it is factored in relation to quantum, not principle. Because there's a causal link, I accept, between that objective and the costs incurred, but there's no finding that trying to achieve a standalone fact-finding hearing was determined to be unreasonable. That finding wasn't made or sought.
Does the judge address it at all? I mean, he refers to the rule which says both parties, but I mean, forgive me if I'm missing it, I probably am, but where does he say? Well, the father's saying there was a big step change in the way the proceedings were conducted by the mother, but it seems to me that was absolutely fine. So I don't regard that as a factor to take into account, or I do, but not very much. I mean, does he say anything about that?
No, he doesn't. But it's not, my lord. It wouldn't simply be enough to say that there was a step change, for it to sound in costs in children at proceedings. The court would have had to conclude, in my submission, that the mother's invitation to the court to have a fact-finding hearing at that juncture was unreasonable. And the court didn't find that. The court disagreed with the mother. The court was not satisfied, and there was no appeal against that decision. The court was not satisfied that it was necessary to have a separate fact-finding hearing. Of course, as we've already seen, Judge Roberts reserving with some scepticism whether there could be an element of fact-finding at the roll of that final hearing.
Doesn't this come directly within the words in brackets quoted in paragraph 89, which includes in particular the efforts made, if any, before and during to try and resolve the dispute? Whereas what we've been told is that before the step change, it was ticking along nicely and it looked as if it was going to be resolved, and then a change happened and the nuclear bomb was dropped.
But my lord, again, if one examines that superficially attractive submission, the nuclear bomb was dropped, but the mother was still saying there should be contact between N and the appellant.
She wanted a fact-finding hearing, which the judge who found against it said would devastate both parties and cause unutterable damage.
That is what Her Honour Judge Roberts said. But Her Honour Judge Roberts did not, and no one has said, and in my submission, nor could have said, that it fell into the category of unreasonable conduct for a mother to seek a fact-finding hearing to establish narrative, not risk.
All right, we have your point on that.
Thank you.
Now, it's just about returning. How are we getting on?
If you'll excuse my platform then, my lady.
Of course, don't want to rush you.
I'm obliged to my junior. Just what one.
Well, I mean, take stock over the short adjournment.
Sorry.
I mean, I'm afraid, as you won't be surprised here, we've all got meetings.
Yes.
It's a short adjournment. May I just flag up one thing that I just would like your submissions on, because of course the judge went on to consider, quite properly in this respect, went on to consider whether or not there should be an order for indemnity costs by reference to Three Rivers, and concludes at paragraph 107. By application, he says, of Three Rivers, that there's insufficient in his conduct to be considered to lead to indemnity order. And it just, when you look at the particularly paragraph 100 and Three Rivers, I'm just wondering how, on your case, if you could you just help us with that, whether those are two inconsistent conclusions? That would help if you could. Very well, thank you. May we say 2:05? I think we've been rather cluttered up. I apologise for that. I think we've been rather overloaded with meetings.
All rise if able.